Today I'm going to go over a little bit about what I went over in the last few days, reference the independent states and the dependent states. So here's a map that's a little bit easier to understand versus the stuff I drew on the board in the last couple videos. And this way you can see a little bit better the independent states. And you notice on the map it just says Texas, Oklahoma, Kansas, Missouri, Illinois. It doesn't say state of. They never say state of on the map. These are the states, the independent states that were created by the people at large who lived in the area, and that's how independent states are created. These independent states joined a confederacy, which is a firm league of friendship. In that firm league of friendship, they recognized that the states were called free, sovereign, and independent. So each of the independent states are free, sovereign, and independent. The states, once they started, the colonies, once they started becoming states, started to recognize the need after the revolution to create a better defense system than what was in the Confederation. I've read that in order to repeal any kind of law, you have to write the repealing clause in the new law. So the Constitution says it's a more perfect union. So in my mind, that means that the two go together. The Articles of Confederation and the Constitution work together. If they don't work together, and it was the Constitution to totally repeal and replace the Articles of Confederation, the Constitution would have to have a repealing clause. And a repealing clause looks like, this Constitution repeals the Articles of Confederation written in whatever date they were passed in. So there is no repealing clause in the Constitution, and that's a requirement, and it's a requirement that goes back to ancient times. And the founders knew about the repealing clause because they had used it prior to writing the Constitution and after. It's been used in the laws ever since. So to say that the Constitution just repeals the Articles of Confederation and having no actual evidence of it is something a school child would do. We can't just believe these things just because they say them. That's what politicians do. They lie. They're really good at it, and they've been lying for a long time. If you can find a repealing clause for the Articles of Confederation, consider posting it in the comments, because I'd love to see it. So what I explained to you in the previous videos is that the states, once they started becoming states, they were independent, yet they needed a strong defense. And they created a defense by annexing small amounts of lands in the state. That's what an annex is. It's not taking the whole thing and giving it away. Why would you do that? Why would you need to give all your land to a small place in Washington, called Washington, D.C., which is also just a state? Why would you need to do that? And why would you do that? Washington is intended to be used to delegate authority in times of war. And that authority is delegated to only the lands for defense purposes. These lands for defense purposes are considered military lands under exclusive legislative jurisdiction, which I talked about. Meaning DC has the sole right to make all laws for the federal lands. Now there are some shared lands, such as the roads, because they need to travel from post to post and from state to state and from states to Washington, so the representatives can meet up in a central location for war efforts. And then they go back And I think a big clue to that is in the Constitution, where it says that they wanted the Congress to meet at least just once a year. So nowhere a treaty for peace, and when you're elected, you got to plan on going at least once a year. After that, in a time of peace, there's no reason to be there all the time. And I think that's what the founders actually intended to happen. So once the federal areas were created for defense purposes, they were finding problems with acquiring essential services on those military posts. So they needed to contract with the independent state to see if they could use the services off the military posts, off of the lands for defense purposes. And the way they did that was to write laws that weren't part of the Constitution. So they're not actually laws. They can't be laws because they're not passed in the way a law would be passed. They're different, but the differences are very subtle. One problem that Congress is well known for doing is writing vague laws, and that's been well known for quite a long time. But I'm not sure that they're really vague laws as far as being uneducated and trying to read the laws and not really understanding what you're reading, or being a lawyer or attorney and reading the laws or non-laws and really understanding what's being said. So I think that's a fundamental issue that people have when they're trying to read the contracts between the dependent states and the independent states. Is they're reading the business contracts and they're thinking that they're laws, but they're not, because they're missing a fundamental component to actually being passed into a law, and that's a positive law citation. So a positive law citation is required in order for a title to be passed into law. And it's usually found in the enacting clause. Now, the enacting clause is required for laws, okay? For the laws. But the thing is we look at them and we think the whole list of titles are laws, but they're not. They're not, because some of them have no positive law citation. Now, you can Google this, OLRC, or the Office of the Law Revision Council, and go to the website, and you'll see what I'm talking about. In Title I, Chapter 3, you have to click on the plus to expand it. Title I, Chapter 3, Section 204, you get here and you go across the page and you click on View. And that's going to bring up Section 204 and you can read it. In Section 204, says that in order to be considered a law or passed properly into law, the title would need a positive law citation within the enacting clause. And we can find an example of that just by clicking the, I believe it's the front matter to Title I. Positive law citation. If you click on front matter, so you'll see Title I, when you go in there, you see Title I, and just under Title I here, it says front matter, and you go over and you click View, and it'll bring up the positive law citation. This title has been made positive law by Section 1 of Act July 30, 1947, Chapter 388, 61 Stat 633, which provided in part that Title I of the United States Code, entitled General Provisions, is codified and enacted into positive law and may be cited as 1 USC section, whatever section you're citing. So if you like, you can go there and do that. And December 9th, this text contains laws. If you go to section 204, it's shown as, this is the way they cite it. So if it's made positive law, you would cite it this way. Title 1 U.S.C. United States Code. Now this, it says right under there, text contains those laws in effect on December 9th, 2020. So they're constantly changing these laws. They're updating them. They're taking things in, putting things out, and it looks like this has actually been changed since the last time I looked at it. But, okay, here it is. That whenever titles of such codes shall have been enacted, a requirement, into positive law. Law is an important word. It's not just a title anymore. If it's been made positive law, it's now a law. If it doesn't have a positive law citation, it's not a law, it's just a title. It's just a compilation of things, of writings. The text thereof shall be legal evidence. Legal evidence, okay? That's an important term also. Therein contains in all the courts of the United States. So if it has a positive law citation, it becomes legal evidence of having been made a law, okay, in all the courts of the United States. Okay, so what does that mean? So that means that without a positive law citation, it's not evidence. It's not legal evidence in all the courts of the United States. So how is it that these titles, not made into a law, is used as legal evidence in courts? Okay, I'm gonna explain that to you.